Okay, let's unpack this.
Hmm.
If you've ever wondered what separates, a tragic accident from an actual punishable crime, well, the answer really lies in two core concepts. We are diving deep into the absolute foundation of criminal liability, the physical action, and the mental state. We're pulling the critical legal knowledge right from your sources to figure out exactly where the law draws that crucial line.
Right. And to really understand that line, we have to rigorously analyze two fundamental elements. Actus reus, that's the physical act itself, and mens rea, the culpable mental state. We'll lay out the core rules for each, then we'll test those rules using specific court cases, some pretty compelling hypotheticals too, and then look at how doctrines like, say, strict liability or mistake can actually negate the elements needed for a crime.
Okay, let's start with the physical side of things. What's the legal significance of that old saying, the bad thoughts alone can't be a crime? And what is the core requirement, the actus reus, that must be present?
Well, the basic principle, the foundation really, is that criminal liability has to be based on conduct. And that conduct must include a voluntary act, or sometimes an omission, a failure to act, but only where there's a legal duty. If the act isn't voluntary, it just isn't an actus reus. Simple as that. The Model Penal Code, the MPC, it defines a voluntary act pretty clearly as a product of the effort or determination of the actor. So, bodily movements that are explicitly defined as not voluntary, things like reflexes, convulsions, movements during unconsciousness, sleep, hypnosis. That whole category is called automatism, and it can be a complete defense.
That makes intuitive sense, right? If you're asleep, you can't really be forming criminal intent. But let's test the edges of that voluntary idea. What
Yeah.
about unconsciousness? How did the court handle that in State v. Cadell? Let's analyze State v. Cadell. So first up, what are the legally key facts?
Okay, Cadell. The key facts involved a defendant who basically claimed his illegal actions happened while he was unconscious, in a state of automatism, meaning, his body moved, but his mind wasn't directing it.
And the core legal issue.
The issue is really twofold. Is unconsciousness or automatism a complete defense because it negates the voluntary act? And maybe more critically, did the prosecution need to prove he was conscious right at the moment the act occurred?
What rule did the court land on?
The rule is, well, it's nuanced. True unconsciousness does negate the voluntary act requirement, that's clear. But, and this is crucial, liability can still attach if that state of involuntariness was, let's say, caused by an earlier voluntary act done with the required mental state.
Ah, so like a prior choice.
Exactly. That's the temporal exception.
Okay, so what was the court's analysis then? How did they connect those dots?
The analysis really focuses on linking that immediate involuntary act back to a prior conscious voluntary choice. So the classic example, if someone knows they're prone to seizures but decides to drive anyway, well, the law might view the voluntary act as the decision to get behind the wheel, made with awareness of that risk. It effectively reaches back in time to find that culpable choice.
And the conclusion from the court?
The court held that, yes, genuine automatism is a complete defense, but that defense is knocked out if the involuntary state resulted from a prior voluntary and culpable act.
Okay, here's where it gets maybe even trickier. What about not doing something? A failure to act? When can an omission satisfy the actus reus requirement, even with zero physical movement? We know there needs to be a legal duty to act, not just, a moral feeling. So what are the main sources of that legal duty?
Right. An omission only counts, legally speaking, if the defendant had a pre-existing legal duty to act, and the law recognizes 5 main sources for that duty. 1, statute the law specifically requires you to act, like reporting certain things. 2, status relationship, think parent-child, spouses, that sort of thing. 3, contract, like a lifeguard or a nurse who's contractually obligated to provide care. 4, voluntary assumption of care, this is where you start helping someone and you seclude them, preventing others from stepping in. And 5, creation of peril, where you cause the danger even if you did it completely accidentally.
Let's use a really visceral example for that last one, the creation of peril, just to lock it in for you, the listener. Imagine someone trying a harmless prank accidentally knocks their friend into a freezing river. They totally panic, run away, and the friend drowns. Now, since the initial push was just a joke, totally innocent, no mens rea to harm, could they still face liability for the death?
Oh, absolutely. Yes, even though that initial push was innocent, it still created the risk of harm. That act, even accidental, instantly imposes a legal duty to render aid. So the failure to act afterwards, the omission, that satisfies the actus reus requirement. Potentially for something like manslaughter. Their panic, their feelings, totally irrelevant legally. The duty arises from creating the danger.
Okay, shifting gears now, let's move to the mind. The maxim is actus non facit reum nisi mens sit rea. The act isn't guilty unless the mind is guilty too. Common law intent was, well, kind of a mess. How does the Model Penal Code, MPC, try to simplify that old chaos of general and specific intent?
Yeah, the MPC really aimed for clarity. It standardized the culpable mental states and, crucially, required that culpability apply to each material element of the crime. It basically tossed out the old labels and brought in 4 clear mental states in descending order of, let's say, blameworthiness. 1. Purposely. Your conscious object is to do the act or cause the result. 2. Knowingly. You're aware of what you're doing or you're practically certain the result will happen. 3. Recklessly. You consciously disregard a substantial and unjustifiable risk. You see the risk and ignore it. And 4. Negligently. You should have been aware of a substantial and unjustifiable risk, but you weren't. It's an objective standard, unlike recklessness, which has that subjective awareness piece.
Okay. Purposely seems straightforward,
Sure.
but proving knowingly.
Yeah.
What if the defendant just says, I didn't know?
Hmm.
How can prosecutors handle that? What are the elements of the willful blindness doctrine?
Ugh. Willful blindness. It's basically a tool to stop people from using deliberate ignorance as an excuse. The law can infer knowledge if the prosecution proves 2 things. 1, the defendant was aware of a high probability that the fact exists, like they strongly suspected it. And 2, they deliberately avoided confirming that fact. They intentionally stuck their head in the sand, so to speak.
Let's look at U.S. v. Jewell, the classic marijuana in the secret compartments case. It seems to hit this exact point. Let's analyze U.S. v. Jewell.
Yeah.
Okay, starting with the facts. What happened there?
Right, Jewel. You had a defendant driving a car across the border. He knew there was a secret compartment, probably even helped install it or knew about it being installed, but claimed he deliberately didn't look inside to see what it contained, which turned out to be marijuana.
And the core legal issue.
The big question was, can that deliberate ignorance, that sort of willful shutting of the eyes to the high probability of drugs being in there, legally substitute for the actual knowledge the statute required?
The rule did the court apply?
The court essentially said yes. It affirmed that willful blindness can satisfy the knowledge requirement, provided those 2 elements, high probability awareness and deliberate avoidance, are met.
And the court's analysis. What was their reasoning?
The reasoning was really driven by policy. They argued that deliberately avoiding facts, are highly probable, is, for legal purposes, the same as knowing them. The law shouldn't reward someone for intentionally creating their own ignorance to dodge liability.
Then the final conclusion.
The holding was that the jury could infer the required knowledge based on Jewell's deliberate ignorance. It was enough.
Okay, so most crimes need some mental state.
Yeah.
But what if the law, the statute itself, is just silent? Doesn't mention mens rea at all. What is a strict liability crime, and what are those 5 factors courts use to figure out if that's what the legislature actually intended?
Right. Strict liability crimes are the exception. They require no culpable mental state for at least 1 key element. Now, a statute is silent. The MPC actually defaults to recklessly as the minimum required state. The common law default tends to be at least negligence. But to figure out if the legislature intended strict liability, courts weigh 5 factors. 1, the severity of punishment. Lower penalties, like fines, suggest strict liability might be okay. Serious jail time, less likely. 2, the nature of the harm. Is it a public welfare offense, think food safety traffic laws, or a traditional morally blameworthy crime, what lawyers call mala in C? Public welfare offenses are more likely candidates for strict liability. 3, difficulty of proving mens rea. If proving intent would be almost impossible, that might favor SL. 4, frequency of the crime. High frequency might suggest a need for SL for effective regulation. And 5, the actor's ability to apprehend the facts and prevent the harm. Can people reasonably be expected to know and comply?
This feels like a potentially big power for the legislature, just removing the mental element. Is there like a constitutional boundary here? Let's look at Lambert v. California. That dealt with passive conduct, right?
Yeah.
Let's analyze Lambert v. California. Okay, first, the legally important facts.
Okay, Lambert. The key fact was a Los Angeles city ordinance that required anyone previously convicted of a felony to register with the police if they were in the city for more than 5 days. Lambert was convicted under this ordinance simply for being there without registering. Crucially, there was no evidence she even knew about the registration requirement. It was purely passive non-action.
And the core legal issue there.
The issue was whether the Due Process Clause of the Constitution allows a city to impose criminal liability for a completely passive failure to act, just failing to register when the person had no knowledge whatsoever of the duty to act.
What rule did the court apply?
The Supreme Court applied a due process rule here. It held that due process actually prevents imposing criminal liability for a purely passive failure to act if the defendant had no knowledge of the legal duty, especially when circumstances wouldn't prompt inquiry. This set a constitutional limit specifically for passive conduct.
Interesting. And the court's analysis. Why draw the line there?
The analysis centered on fundamental fairness. When the conduct is purely passive, just being somewhere without filing paperwork, punishing someone who is completely ignorant of the law, and where the government hasn't really made an effort to inform them, well, that violates basic due process concepts. It's different from active conduct.
And the conclusion.
The holding was that the ordinance was unconstitutional as applied to Lambert because she was unaware of her duty to register. Her conviction was overturned.
Okay, so we have the act, we have the mind, let's connect them. The law generally requires them to happen together, right? Not a guilty act on Tuesday and a guilty thought on Friday. What are the two types of concurrence needed? Temporal and motivational.
Exactly. You need both. Temporal concurrence means the culpable mental state, the mens rea, has to exist at the same time as the actus reus. They have to overlap temporally. Motivational concurrence means the mental state must match the result. The harm you actually cause has to be the kind of harm you intended or consciously risked. So if you plan to kill someone, but then you change your mind completely and later you accidentally hit them with your car, well, there's no temporal concurrence between the original intent and the accidental act.
Okay, but what about those really weird cases, like the Thabo Melli situation, where someone thinks they've killed the victim with a first act, so they do something else, like throw the body off a cliff to hide it, but that's what actually causes the death? How does concurrence work there?
Yes, the Thabo Melli problem. Courts generally handle that by viewing the entire sequence of events as a single continuous criminal transaction. They essentially link the initial intent to kill the mens rea from the first blow to the eventual fatal result, even if the act that actually caused death, like hiding the body, didn't have on its own the specific intent to kill at that exact moment. The initial guilty mind is seen as driving the whole course of conduct.
Got it. Okay, let's tackle mistake. Now, mistake isn't magic defense on its own, right? It has to actually negate one of those mental elements we talked about. So how does analyzing a mistake of fact change depending on whether the crime requires purpose knowledge or recklessness or maybe just negligence?
That's absolutely key. A mistake only works if it prevents the prosecution from proving the required mens rea, and the rules change depending on that mens rea. This is critical. If the crime requires purpose or knowledge, then even an unreasonable mistake can be a defense as long as it's honestly held. Why? Because if you honestly believe something, however dumb that belief might be, you simply cannot have acted purposely or knowingly regarding the true fact. Your subjective state is what matters. Now, if the crime requires recklessness, the mistake has to be such that it prevents you from consciously disregarding the risk. If you honestly don't believe the risk exists, you can't consciously disregard it. But if the crime only requires negligence, then the mistake must be reasonable. An unreasonable mistake won't excuse negligence because negligence is all about failing to perceive a risk that a reasonable person would have perceived.
Wait, hold on. So you're saying if a crime requires purpose or knowledge, like maybe theft, being genuinely, honestly, but unreasonably mistaken about owning something could actually be a defense. That seems generous. Let's see that tension in State v. Sexton. That case involved a mistake negating recklessness, right? Let's analyze State v. Sexton. Okay, the legally relevant facts.
Yes, Sexton. The defendant was involved in a situation, basically horseplay with a gun, that resulted in an accidental shooting death. His defense was that he genuinely honestly believed the gun was unloaded. Now, that belief might have been incredibly careless, maybe even objectively unreasonable, but he claimed it was honest.
And the core legal issue.
The issue was whether that honest, even if potentially unreasonable, belief that the gun was unloaded could negate the subjective awareness component required for recklessness, which was the mental state for the manslaughter charge he faced.
What rule did the court apply?
The court applied the rule straightforwardly. If the defendant genuinely believed the gun was unloaded, then logically he could not have consciously disregarded a substantial and unjustifiable risk of death. Believing it was safe means he wasn't subjectively aware of the danger.
Okay, and the court's analysis on that point.
The analysis really hinged on that subjective element of recklessness. They said, look, recklessness requires the defendant to be aware of the risk and ignore it. If the jury buys the defendant's story that he honestly thought the gun was safe, then that subjective element is missing. It doesn't matter if a reasonable person would have checked more carefully. That goes to negligence, not recklessness.
And the conclusion.
The holding was that the honest mistake, even if it was unreasonable, served as a valid defense because it negated the specific mens rea of recklessness required for that crime.
All right, last major piece. Mistake of law. What's the crucial difference between a mistake of collateral law and a mistake of penal law? And why is the general rule so harsh? Ignorance of the law is no excuse.
Okay, the distinction is important. A mistake of collateral law is a mistake about some non-criminal law that happens to be relevant to the crime. Like maybe you're mistaken about whether your divorce was final when you remarried, bigamy, or whether you actually own property you took, larceny. The law generally treats these like mistakes of fact. The analysis depends on whether the mistake negates the required mens rea. But a mistake of penal law, that's a mistake about the existence or the meaning of the actual criminal statute you're charged with violating. And here the general rule is ironclad. Ignorance is no excuse. Why? Pure policy. If everyone could just claim they didn't know the law or they read it differently, the whole legal system would basically collapse. So this defense is almost never allowed, except in really narrow situations, usually involving the government itself, misleading the defendant, like relying on an official interpretation that turns out to be wrong, or maybe if the law wasn't even published, relying on your private lawyer. Nope, doesn't count.
Well, see, that tough rule applied in People v. Marrero. Let's analyze People v. Marrero. So what were the dispositive facts?
Marrero. He was a federal corrections officer working at a federal jail in New York City. He was caught carrying a loaded pistol in a nightclub, which was illegal under New York state law. His defense was that he genuinely believed a provision in the state law exempted peace officers, and he thought, based on his own reading, that his federal job qualified him as a peace officer under that state law. It was purely his personal interpretation.
And the core legal issue.
Simple. Can a defendant's personal mistaken interpretation of the criminal statute itself, a mistake of penal law, excuse their conduct?
What rule did the court apply?
They applied the classic strict rule. Ignorance of the penal law is no excuse. They emphasized that his mistake was entirely based on his own reading and understanding. It wasn't based on any official statement or interpretation from a New York state body or official, which might have triggered one of the narrow exceptions.
And the court's analysis. Why so strict?
The analysis, again, was heavily policy-driven. The court basically said that allowing people to be excused based on their own misunderstandings of the law would create chaos and undermine the very principle of the rule of law. The exceptions exist only for situations where the government itself is essentially at fault for the mistake.
And the conclusion.
The conclusion was straightforward. Marrero's mistake of penal law was not a valid defense. His conviction for weapon possession stood.
Wow. Okay, that is a lot of dense legal doctrine. We've covered actus reus, mens rea, all the nuances. For you, the listener, maybe facing an exam or just trying to understand this stuff, we really need a clear roadmap. Can you synthesize all these rules into one kind of actionable diagnostic checklist?
Absolutely. Let's boil it down. To properly analyze any potential criminal liability, you really need to follow a systematic approach. Think of it like this checklist. 1, identify the conduct. Is it an act? Or is it a failure to act, an omission? That's your starting point. 2, test for voluntariness. If it's an act, was it voluntary, willed, conscious, or was it involuntary automatism? If it seems involuntary, don't forget to check. Was there a prior voluntary act done with a guilty mind that caused the involuntary state? 3, analyze omission. If it's a failure to act, you must find a legal duty. Pinpoint the specific source, statute, status, contract, voluntary assumption of care, or did the defendant create the peril? No duty, no liability for omission. 4, check for strict liability. Look at the statute defining the crime. Is it silent on the mental state? If yes, apply those 5 factors: severity of punishment, nature of harm, public welfare, difficulty of proof, frequency, actor's ability to know to see if the legislature likely intended any element to be strict liability. Remember, Lambert limits this for passive conduct. 5, determine required mens rea. For every element not strict liability, identify the specific mental state required by the statute or by default rules if silent. Is it purposely, knowingly, recklessly, or just negligently? 6, test the mistake. If the defendant claims mistake, first classify it. Is it fact, collateral law, treated like fact, or penal law? If fact or collateral law, test it against the required mens rea you found in step 5. Remember, even an unreasonable mistake can negate purpose or knowledge. Only a reasonable mistake negates negligence. If it's penal law, is it one of those super narrow official reliance exceptions? Probably not, but check. 7. Conclude. Okay, putting it all together. Can the prosecution prove beyond a reasonable doubt the required actus reus, voluntary act or omission with duty, the specific mens rea for every element, and that they occurred concurrently? If yes to all, then liability likely attaches.
That is incredibly clear, a really powerful framework for cutting through the complexity. So the line between accident and crime, it really comes down to meticulously checking each of these boxes, the act, the mind, the duty, any mistakes. It's all connected.
It absolutely is. And we've covered the core elements needed for a completed crime here. But, the law doesn't always wait for the final harm to occur. So maybe something for you to think about next is what happens before the crime is finished? Consider the whole area of inchoate crimes, things like solicitation, attempt, and conspiracy. How does the law punish just the steps toward a crime, often focusing heavily on that mens rea, even when the actus reus is incomplete? That's where the law gets really interesting in preventing harm before it happens.